Dozens of convicted sex offenders in Charleston County live within 1,000 feet of schools and parks, but they're legally allowed to be there because of loopholes in South Carolina law that haven't been updated in 15 years.
Live 5 investigative reporter Emily Johnson exposes the gaps in state law and tells us how registered sex offenders are allowed to live dangerously close to children.
In the quiet neighborhood of Old Village Mount Pleasant, children practice tennis, bike to their friends' houses, and play with dogs in the park. But a convicted sex offender lives just around the corner.
There is no good place for a child sex offender to live, but this might be one of the absolute worst locations.
Living next door to mother Sarah Mitchell is Travis Reed Gay. Gay was charged with multiple counts of sexual exploitation of a minor in 2023. Last November, Gay pleaded guilty to one count, was placed on the sex offender registry, and served no prison time. Gay remained at his parents' Mount Pleasant home.
But you get out to the suburbs and 1,000 feet isn't very far. And in this case, 1,000 feet does include 3 children's recreational facilities and 2 parks.
Just a month after his plea hearing, South Carolina's Department of Probation, Parole, and Pardon Services arrested Gay for allegedly possessing sexually explicit materials. Gay is still awaiting a hearing in criminal court.
Everyone's upset because this sex offender is back in the courts, even though the law said there would be jail time.
We investigated how many sex offenders live near schools in Charleston County.
We found more than 40 living within 1,000 feet of a school, according to the Public Sex Offender Registry.
For example, 2 convicted sex offenders live within 1,000 feet of Charleston Progressive Academy. A convicted rapist and kidnapper lives 600 feet away from A.C. Cochran Elementary School. A repeat sex offender lives 5 houses down from Daniel Jenkins Academy.
South Carolina law hasn't changed in 15 years, and it's full of loopholes.
There doesn't seem to be any mechanism, if you will, to assist local law enforcement in notifying them of any infractions. And so when I say that it is reactive as opposed to proactive, there's no real monitoring of this.
South Carolina law bans sex offenders from living within 1,000 feet of schools, daycares, parks, and playgrounds, but only if they're convicted of one of 5 specific crimes: criminal sexual conduct with a minor in the first and second degrees, assault with intent to commit criminal sexual conduct with a minor, kidnapping a person under 18, or trafficking a person under 18.
Really, every sex offender should have a limitation on where they could live, no matter what the charges are, even if they do plead down, because there really should be a minimum 1,000-foot rule so we can keep our communities safe.
We found examples of offenders living near CCSD schools who are convicted of rape, child molestation, sexual abuse of a minor, criminal solicitation, assault, or possessing child pornography. But these offenders are all legally allowed to live near children because their charge is not included in state law.
Solicitation of a minor, not listed in the statute. Would you want that individual living within 1,000 feet of a playground or a school? Absolutely not. But the statute doesn't cover them at all. And I can't really explain why.
CCSD parent Joy Brown checked the sex offender registry after sending her children to school one day. She discovered something unimaginable.
Actually, the bus stop was the driveway of a registered sex offender.
Brown contacted CCSD and the bus stop was moved within a week.
I think it's shocking to me that everything's falling in the cracks, and we're supposed to be protecting our students. Our kids are the ones who we have to worry about.
State law requires school districts to notify parents at the beginning of each school year about every sex offender living within 1,000 feet of a school bus stop. Brown says she never received that notification.
Knowledge is power, so if we know, then we are empowered to do something about it and to advocate for our kids.
State law hasn't been updated since 2010, years before the rise of social media and online exploitation.
Our legislators have not caught up with any of that, and they have not included every potential offense one could commit against a child.
And even if a sex offender was convicted of one of those 5 crimes, there are still exemptions. Offenders can stay if they lived there before their conviction, before the law took effect, if a school or park was built after they moved in, or they live in a specific shelter or facility.
All of these guys, frankly, belong on the outskirts of society.
Based on our investigation, we found at least 15 registered offenders appearing to be in violation of state law because of the nature and severity of their charges. But verifying whether or not they're in violation of that law is nearly impossible.
The Sex Offender Registry does not publicly list if someone is allowed to live within 1,000 feet because of exemptions.
So if you're trying to, as a concerned citizen, piece this together, you'd have to play super sleuth online to figure out whether they're exempt or whether they're in violation.
A new bill is currently in South Carolina's House with proposed modifications. It would add community playgrounds and homeowners associations to the list of restricted areas. It would also ban sex offenders from owning or working at any business with unsupervised access to children.
We have people registered, but it needs to go a step further in order to be truly, accomplish the mission they're setting out to accomplish, which is to keep these sexual predators away from children.
But the proposed bill doesn't update how parents are notified, add additional crimes to the restrictions, or implement stronger monitoring. Until existing laws are updated and properly enforced, parents say they must take on the responsibility of protecting their own children.
There's a formidable group of moms in Mount Pleasant, women with a lot of grit, and I think they are all going to be watching and waiting, and I certainly hope that justice prevails this time around.
It's terrifying. You want to know that your school is a safe place to be. We really need to collaborate and make sure that is not something that is falling through the cracks.
Local law enforcement is responsible for making sure that people on the list don't live where they're not allowed to be. We asked the Charleston County Sheriff's Office for an interview to answer some of our more specific questions, but they denied our request. CCSO says its sex offender registry unit is responsible for the management of the registry in Charleston County. The agency released a statement that reads in part, quote, "This unit conducts field checks of sex offenders to ensure compliance with state law and registers a high number of offenders, often exceeding 800 at any given time." Additionally, the unit oversees the registration process, including address verification and updates to keep the public informed about registered sex offenders in the area, end quote. CCSD released a statement that reads in part, quote, "The link to the state's sex offender list is posted in multiple locations on the Charleston County School District's website, ensuring the district is in compliance with state law. It is vital that our families feel secure in our efforts to keep our students safe," end quote. We also reached out to Travis Gay's attorney, but did not receive a response. For Live 5 Investigates, I'm Emily Johnson.